Well, the scene for me has been set by the two presentations this morning. What I would like to do would be to have a look at some of the detail of trade negotiations, and in particular ask what sort of lessons have we learnt about trade negotiations over the last 30 years or so. There are two important trends I want to draw your attention to by way of background. The first one is what scholars of regulation and governance are calling the emergence of the regulatory state. The idea is here that Thatcher and Reagan, far from leading us into a deregulatory agenda, actually ended up leading us into a regulatory agenda. So, for example, if you deregulate telecommunications, you end up creating, ultimately, a telecoms regulator. If you deregulate water, you end up creating a water regulator. And empirically, we know that by the end of the Reagan and Thatcher era, there was actually more regulation in both the US and in the United Kingdom than when those two people took office. And the demand for regulation and, more broadly, governance has to do with risk management. Publics around the world are concerned about risks. Risks to health, risks to the environment, risks to personal safety. And so there's been an explosion of demand for regulation and for governance. Regulation, of course, takes many forms. It's not just about command and control anymore. The second important trend is what's happened in the area of trade. Trade used to be about a negative thing, that's to say, to get rid of tariffs. But beginning with the Uruguay round, or really before that, trade began to move into areas that are called non-tariff trade barriers. And one of the consequences, so what we see now from the trade regime are much more forensic interventions into a country's regulatory system. So we have the sanitary and phytosanitary agreement, we have the technical barriers to trade agreement, we have the services agreement, we have intellectual property rights, things that were not part of the trade regime. And one of the big differences is that these things, these new areas of the trade regime, require states to do things, to intervene in their own system. So the trade regime itself is contributing to regulatory demand, and it's placing enormous strains on the capacity of states to regulate. So what we see in developing countries is a demand for an understanding and a knowledge of regulation. So if you didn't, for example, if you didn't have a patent law and you joined the WTO, one of the first things you have to do is to basically set up a patent office, and that's not easy to do. It requires quite a lot of experience, quite a lot of knowledge. So we now have this complex interaction between the demand for regulation and the trade regime. And in particular, the trade regime is being seen as a source of risk. So we think of regulation, the role of regulation as managing risk. One of the things is that the trade regime itself has come to be seen as a source of risk because of its much more or greater interventionist nature. And that partly has to do with many more people getting involved and the emergence of civil society. So it's a kind of complicated picture. No one has all of the answers. But still, if we look at trade negotiations and we look at the interaction between trade and regulation, we can derive some lessons. I'm just going to talk about 5 lessons. I'm not saying these are the only lessons, there are perhaps more lessons, but these are certainly important lessons. The first one is that in knowing the effect of the trade regime or trade agreements, it's very difficult to actually know what the effects of these things will be in the long term or even the medium term because of what I call the principal rules cycle. So trade regimes are characterised by, or trade agreements are characterised by a principal rules cycle, and at the time you're negotiating the agreements, it's actually very difficult to know what will happen and what the real costs or the real benefits will be in the rules cycle. The second thing we know is that multinational companies use trade agreements to push for regulatory models that are favourable to their globalised chains of production. Now, this was a process that really began in the 50s and 60s. So multinational companies were very early entrants into shaping what rules that ultimately would affect both the regulatory capacity and regulatory autonomy of states. So this is a very long-term process. The third thing we know from trade negotiations is that sovereign equality, because under international law all states are equal, but what we know actually from a lot of empirical work is that sovereign equality does not trump inequality of bargaining power. There are lots and lots of sources of bargaining power. So domestic market size matters. So if you've got a very large domestic market, you can use that to leverage a deal on, say, telecommunications that you wouldn't be able to leverage if you're Fiji or Vanuatu. Large states tend to have much more information, so there are quite profound information asymmetries. That matters to bargaining power as well. There are many more levers that a large state can pull. So if a large state is negotiating with a small state, a large state will say to a small state, well, you know, we can do things or do things to you using the IMF and the World Bank. And of course, the small state doesn't have access to votes on the IMF or the World Bank. So there are lots and lots of ways in which bargaining power trumps sovereign equality. The fourth thing, and we know this, this has become very clear now, is that managing trade agreements, and they have to be managed, you can't just sign them and walk away from them, you have to manage them, requires an enormous level of regulatory capacity, that's the sort of on the demand side, and a huge level of regulatory coordination. And that's almost always underestimated. And I'll come back to that and illustrate that. And fifthly, we also know, because of the increased rule complexity of the trade regime, states have to invest much more in litigation capacity. And of course, that's easy to do if you're a state that has an adversarial legal culture. If you have a tradition of doing things through law, that gives you a comparative advantage. If you're a state that doesn't have that sort of institutional and historical culture of law, learning how to litigate your way to victory in a trade dispute is a sort of more problematic process. So people refer to these things, or economists call them preferential trade agreements, and other people call them free trade agreements. I like to refer to them as ELAs, expensive litigation agreements. Okay, so now let me illustrate these lessons. So, lessons 1, 2 and 3, just to remind you what lessons 1, 2 and 3 are about. That's knowing the principal rules cycles, the point about multinational business models and sovereign equality. So let's... Now, I know, unfortunately, I have to dash after this, and I know there's a session this afternoon on the TPP, but what I thought I'd do is just to give you a little bit of the history of Article 20 of TRIPS, which is to do with the plain packaging legislation that was Australia has passed. Now, this history is actually not very widely known, so it'll be a nice context, as it were, for you for your discussions this afternoon. The other thing is I'm going to break all the good rules of PowerPoint presentation and drown you in text. And so you should think of this session as the joy of text. So we have here Article 20 of TRIPS, which is one of the articles that's involved in the plain packaging dispute currently at the WTO. It's to do with trademarks. Now, I'm not going to read this out aloud, but what you should focus on is the word unjustifiably encumbered, right? The use of a trademark in the course of trade shall not be unjustifiably encumbered. Now, before TRIPS was agreed to, there were a number of other drafts that were trade negotiators were negotiating, right? So there was the Dunkel draft of 1991. Now, the final TRIPS text is the same as the Dunkel draft. Two other texts that we know about. Okay? These are texts that have been publicly released. A draft of October the 1st, 1990, in which the word unjustifiably is no longer present. And then the draft of October the 25th, 1990, in which the word unjustifiably is back in the game. Okay, but where did the whole idea of unjustifiably or encumbering a trademark come from? What's the actual... I mean, did the negotiators just dream this up? Well, the actual wording of Article 20 comes from this text. The Basic Framework of GATT Provisions on Intellectual Property, a document that was released in June of 1988. Who authored that text? Well, that text was released. It's a draft text of the TRIPS agreement, right? It's an actual draft of what multinational business wanted. And the authors are, or when the text was released, it's a statement of the views of the European, Japanese and United States business communities. And what is it that they wanted? They wanted this. That's the actual draft text. It appears on page 43 of their version of TRIPS. The use of a trademark in the course of trade shall not be encumbered by any special requirements. And essentially what happened was the trade negotiators played around with the text that multinational business gave them. So who was behind, which multinational businesses were behind Article 20 of TRIPS? So here's an interesting history, a sequence of events. In 1964, you have the US Surgeon General on the increased health risks of smoking. Very famous report. I'm sure all of you here know it much better than me. I'm not a health person. 1965, the US Congress required health warnings to appear on cigarette packets. The tobacco companies saw storm clouds gathering. So as a result of what happened in the US in the 1960s, they could already see potential dangers. It wasn't just the tobacco companies interested in trademark protection, so were the pharmaceutical companies, because what was happening in the 1960s and 1970s in developing countries were that developing countries were talking about requiring, for example, much more prominence to the generic name of a chemical. So, you know, my wife always says, you know, I'm going to go out and buy some Panadol, and I always say, no, we're going to buy paracetamol, not Panadol. So the reason that developing countries were beginning to look at changing the rules of trademark protection in their countries was that they were beginning to understand the importance of trademarks as a barrier to entry and the kind of consumer dependence that trademarks create. So both the large pharmaceutical companies and, more importantly, the tobacco companies, which already had international business models, they understood the danger. So what we saw in the Kennedy round, the round before the Uruguay round, was an initiative to try and elevate protection for trademarks in the interests of the private sector. So that was already being discussed in the corridors of power in the 1960s. And moves were made in that direction in the 1970s. They failed. The US, in the Kennedy round, was not able to do anything about trademark protection. It tried again and was much more successful in the case of TRIPS. So there are a number of important lessons here. One is that multinational companies, by virtue of their business model, tend to think long term. They see storm clouds, they see problems, they understand risks and opportunities much more effectively than governments. Secondly, they become intimately involved in these negotiations. So not only is it not a negotiation between sovereign equals in terms of formal law, it's a much more unequal negotiation depending on where multinationals throw their weight. The other important point about this is that, and this goes to the principles rules cycle, is that when trade agreements, particularly big ones like TRIPS, are negotiated, or WTO packages, it's never the case that rules are negotiated. So, for example, if you're dealing with telecommunications negotiations, it's never the case that a trade negotiator walks into a room with 600 or 700 pages of his or her domestic telecommunications law and says to his or her counterpart, this is what we want. Rather, what is being negotiated are a set of principles. And those principles then, once they're established, begin to pattern the evolution of rules. So all trade agreements do is to establish principles that then trigger a particular evolution of rules. And this makes trade agreements that establish principles and rules in sectors such as intellectual property and services and phytosanitary standards and so on, very difficult to cost because the rules themselves might not yet have actually been created. And what multinational companies will do will be to establish the principles and then play for the rules. So when you're trying to cost the agreement, it's actually very difficult. And very often the costs only emerge way down the track, by which time the politicians who have signed the agreement have retired, and the negotiators who have negotiated the agreement often have walked through a revolving door into some more lucrative job. So, costs only become clear in the rule cycle. So here's an Australian Senate report which is reporting on the costs of medicines in Australia. Now what you'll see is that between 2005 and 2009, the cost to the government of F2 medicines, essentially generic medicines, have declined by 21.4%. So that's good, unless you're a generic company. But F1 prices, essentially patented medicines, have risen by 35.4%. And it's also clear that the trend of a rise in patented medicines will continue. Now, trade agreements are quite profoundly important to raising the cost of patented medicines. But the costs only emerge way down in the rule cycles. The world doesn't change overnight when a country signs a trade agreement. The point about sovereign equality and bargaining power, well, it's kind of obvious, but we still need empirical evidence for it. There's a lot of it. This is a study by Carolyn Freund from the World Bank. We find evidence that large countries extract greater trade concessions from small countries. This is exactly what you'd predict. This leads to a modified form of reciprocity in North-South agreements. That's just how it is, that if you go into a negotiation with an elephant and you're a rabbit, the stew that you come up with is going to basically taste like elephant stew. It's not going to taste like rabbit stew. That's just how it is. And that's also true for middle powers. Middle powers negotiating with large powers might get a bit more rabbit into the stew, but it's still going to be an elephant stew. Now, what's interesting is, and where you learn more about what states really think are in their best interests, is when you look at negotiations between sovereign equals and where the bargaining power is roughly the same, right? So when you look at trade agreements that countries have signed where they're all roughly equal in all those dimensions I've talked about, what do they actually agree to? And that gives you a sense of where they think their interests really lie. So if you have a look at the original Trans-Pacific Partnership Agreement, not the one you're going to talk about this afternoon, but the original one, the one between Brunei, Chile, New Zealand and Singapore, what did they agree to on things like intellectual property? Did they decide to go TRIPS plus? Well, the answer is no, they didn't. They just chose to endorse the TRIPS standard. So obviously these four countries saw no gain to them in moving to higher standards of intellectual property rights. But when the US or the EU joins the negotiation, typically what will happen will be that you'll get high demands in that particular sector. Now, this brings us back to multinational business models, and it's important to understand multinational business models because they have a profound effect on the content of any agreement. So, this is the value chain for the Apple iPod. Now, many economists are slowly coming to the conclusion that the trade data is misleading in many important ways. So that if you look at, say, the trade balance between China and the United States, it looks like, well, it is the case that China has a trade surplus. And when China exports an Apple iPod to the US, that shows up in the trade data as an export from China to the United States. But actually, that's only part of the story. If you really want to understand who's profiting, who is making money from the Apple iPod, you really need to understand the value chain. So the value chain is that, as you'd expect, US Apple gets $76, $75 gets chewed up in wholesale and retail, $27 goes to Japan, particularly Toshiba, that provides some of the programming. You get some parts, Taiwan, Korea, US, and then Labour chews up the rest. China gets $5. That's what China gets out of that deal, $5. Now, what's very important is that who gets what is also profoundly determined by who owns the intellectual property rights, which is why both for the EU and the US, intellectual property rights are a sort of non-negotiable matter. So while they'll be prepared to make concessions in other areas in order to get a deal done, the one area in which historically anyway they've never made concessions is in the area of IP, and this is why, because of the profits that are involved here and the importance of the IP rights to their economy. So if you look at value chain analysis, the US economy looks a lot stronger and the Chinese economy actually looks a lot weaker. So you're probably wondering what all this has to do with health, and I'm coming to that. A very important phenomenon, and another reason why intellectual property rights are non-negotiable, is because of their importance in what is called transfer pricing. But transfer pricing has been a perpetual problem, and this goes to something that Ron talked about, the difficulty of states raising taxes. Transfer pricing has been a major problem for states, for the fiscal bases of states now for many decades. And it's actually an issue that's very difficult to get traction on. This problem actually over the last decade has grown considerably worse. So in some work I did with a colleague of mine, John Braithwaite, about 10 years ago, we predicted that intellectual property rights would become the major source of transfer pricing strategies in the global economy. And actually, that's one of those predictions that's turned out to be true. We've made lots of other ones that are false, but I'm not going to talk about those. I only talk about the ones that we got right, and we actually got this one right. So here's a quote from JP Morgan, global tax rate makers. Many multinationals appear to be centralising many of their valuable IP assets in low-tax jurisdictions. The reality is that IP rights are easily transferred from jurisdiction to jurisdiction. One of the huge problems here is that it's very difficult to value intangible property. It's very uncertain. So the usual OECD tax rules that apply to intra-company transfers, the arm's length pricing rule, the predominant rule here, is actually in reality extremely difficult to apply. Talk to any tax department, they'll tell you that. So valuing transfers of intangible assets turns out to be very difficult, which is brilliant if you want to shift profits, right? Because you can put a value on a patent licensing agreement and it's going to be very difficult for the tax office to contest that. Now, how does this all come together for health? In the following way. If you're a large pharmaceutical company, you will have a globalised chain of production. So you'll be sourcing your active ingredients from China or India. So you will have a value chain that's not too dissimilar to the one that I showed you for Apple and iPod. Okay. Now, as a pharmaceutical company, you have two objectives in mind. The first is that you want to charge the maximum price that you can to a state for the price of your medicines. Right? So you want to really say to them that these medicines, you know, it's going to cost you a lot because we've got to recover our R&D and all that sort of stuff. So there's the price. But if you get a big price, say the state pays that price, then the second problem you've got is you're generating a lot of income on which you're going to have to pay tax. So you've got two complex objectives to achieve here. The first objective is get the state to pay a lot for the patented medicine. The second is don't pay too much tax on the profit you make from the medicine. So that's why intellectual property rights are so important for pharmaceutical companies, because it allows them to play these tax transfer games, transfer pricing games, to achieve both objectives that they have in mind. And that's, of course, costly for the state in two ways. It creates access to medicines issues, and it also erodes their fiscal base. But you can only play those games assuming everybody in the world has signed off on a set of intellectual property rights. That's why intellectual property rights are non-negotiable. So here's an example of a tax, and the country that's most sensitive to this problem and is trying to do something about it is, surprise, surprise, the United States. So to give you an idea of the scale of the problem here, Microsoft shifted $21 billion to an entity in Puerto Rico. $21 billion. That is half of Microsoft's R&D budget walked over to Puerto Rico. Saved it $4.5 billion in US taxes. In an Irish transfer pricing game, Microsoft shifted $4.3 billion into a little office in Dublin. And if you count the number of people in that office in Dublin and divide it by the profit they made, the tax that they saved, each person in that Dublin office made $11 million profit, which is pretty good labour productivity. I mean, you've got to say, right? I mean, that's amazing. That's fantastic. So US committees are very worried about all of this. You know, what are we going to do? We're being ripped off, blah-de-blah-de-blah. Okay, so doing something about transfer pricing is really hard. I mean, it's hard for the US, and you can imagine how hard it is for countries that don't have the Internal Revenue Service, which, after all, we must remember, did put Al Capone into jail. So, you know, the US has serious firepower when it comes to tax. Many other states do not. Okay, I talked about the need for regulatory capacity and coordination. Now, it's becoming clear, I think, to the BRIC countries in particular, that they will have to increase regulatory capacity to deal with or manage trade agreements. You can't just sign onto one of these trade agreements and assume that everything will work out beautifully for you. You actually do have to manage them in the way that you manage all sorts of other risks. So what is happening, and I'm not going to go through all the BRIC countries, but I'll just give you an example of the way in which some BRIC countries are starting to think about how they might manage these trade agreements. So South Africa, for example, has what many people would say would be a low standard patents law. It basically allows registration, doesn't require examination. So foreign companies can get any number of patents they want in South Africa. But what South Africa has done in order to deal with the cost of medicines is to create a very robust competition commission. So it's invested money in creating regulatory capacity to look at whether there's collusion in the marketplace, whether there's abuse of intellectual property rights, and so on. And so I've just given you two examples of where the South African Competition Commission has intervened in the area of medicines. In both cases, these companies ended up having to give voluntary licenses to local manufacturers. And I think what I can see, and this comes out of a project that I'm currently involved in looking at the BRIC countries and the World Patent Order, a project I'm doing with a few other colleagues, what we see emerging from the BRIC countries is investment in regulatory capacity. Right. Now, not every country will necessarily follow South Africa, and each country will develop its own strategy. But the point is the BRIC countries are developing strategies. So Brazil will have a slightly different approach. It's invested in giving the equivalent of its therapeutic goods regulator more power. There are also there's been a recent bill in Brazil to move its patent law more in the direction of something like India has, and so on. So each country will develop its own strategy. And so one of the lessons that we learn from trade negotiations is that unless you are prepared to invest in risk management, things are likely to work out badly for you. You really have to build regulatory capacity. And the good thing about the world is that there's a lot of regulatory experimentation taking place, and so countries are studying each other's models. But it's very difficult to do regulatory coordination well, and this comes out of another project in which I'm trying to imagine what does regulatory coordination really mean if you're going to tackle the transfer pricing issue? Okay? Because if you think about it, transfer pricing concerns the tax office, it concerns the regulator of pharmaceuticals, potentially, and it concerns the patent office. Now, patent offices don't know much about tax law. Tax offices don't know much about the patent system. So what you actually need is a high level, and this diagram is deliberately complicated, and you know it's meant to be so that you don't understand it, because I don't even understand it myself, but I'm just trying to think through what a responsive institutionalism actually looks like for the world, or for a state. And it requires enormously high levels of cooperation between these regulators in order to deal with the transfer pricing problem. And what we see around the world is almost no shift in this direction. And I'm talking about OECD countries. For the purposes of this project, I'm looking at OECD countries. Forget about developing countries. Now, I can only think of one, I've only come across, looking at the OECD countries, 1 or 2 cases of where we see even a glimmer of understanding of what the issues are. So in Denmark, for example, and in the Netherlands, the tax office and the patent office have entered into a sort of formal arrangement. There's much more sort of interchange. And we also see more exchange of data between the UK patent office and the tax office in the UK. But these are early days. And the scale of the problem, when you have multinationals shifting billions of dollars around through complex licensing agreements, tax officers trying to track that down, it's not easy. Now, all of this has implications for health, because it affects what prices states pay for medicines, and it affects what they can collect in terms of revenue, which affects obviously what they can spend on health. So these 5 lessons, I think, are absolutely clear lessons that we can say unequivocally have been demonstrated by the last 30 years of trade negotiations. Doesn't mean that there aren't other lessons that we could talk about, but these 5 are incredibly important. And the overwhelming message is that if you are going to walk into these trade deals, you have to understand that probably you won't have a clear understanding of what the true costs of the agreement are going to be because of the principal rules cycle, and that the only way to manage the indeterminacy of the costs, the indeterminacy of the effects, is to invest in regulatory capacity. And we are beginning to see an understanding of that in the BRIC countries. But they are the BRIC countries, and they are in a category all of their own. You know, where many African states are on this, many poorer countries in Asia and Africa, they are much further behind in understanding and being able to manage these agreements. Thank you very much.